Good evening. This is environmental law. It's part of our series in relation to guest speakers. Tonight we're very privileged to have environmental scientist Phil Jeston, who is coming back to provide some further commentary in relation to what he had discussed previously in relation to our environmental impact assessment. Phil now works in the public sector, having returned to the public sector after a lengthy stint in the private sector. He is currently a manager in planning and environment, responsible for development and town planning services, ranger services, that's local laws, pest and animal management, and waste and environmental services. He manages over 30 staff at Central Highlands Regional Council, and that covers an area as big as Tasmania. Phil has over 20 years' experience in state government in planning and environmental management, as well as agricultural research, and over the last 10 years has worked in the private sector, working as a planning and environment consultant and advisor. Phil comes to us with a Bachelor of Science with postgraduate qualifications in both public sector management as well as environmental management. And as I said, it's a great privilege to have Phil on board tonight. The main focus of what Phil has to tell us tonight relates to environmental impact assessment. And as you would have picked up from your reading, there are a number of ways in which you may be called upon to consider environmental impact assessment. So the main sources, it's probably fair to say, are in relation to controlled actions under the Environment Protection and Biodiversity Conservation Act, Commonwealth of course, which we will abbreviate typically to EPBCA or EPBC Act. The second is as part of impact assessable matters for assessment development applications under the State Sustainable Planning Act in Queensland, of course, or for a project declared to be a coordinated project by the Coordinator General under the State Development and Public Works Organisation Act. And finally, EIA requirements may be triggered for an environmental authority in respect of mining or petroleum activities under the Environmental Protection Act. Now, Phil's talk tonight follows on very neatly from our previous discussions where Sean Ryan, from the principal lawyer from the Environmental Defender's Office, talked to us from the perspective of a litigant challenging decisions in the context of mining, coal seam gas, etc. So what Phil will be talking about tonight to some degree follows on from that. So thank you very much, Phil. If I could hand over to you now, and as always, people are invited, encouraged to ask questions as we proceed. Thank you, Phil.
Hi everyone, thanks for dialing in. So what I thought I'd do today is basically go through the environmental impact assessment process we have in Queensland, just from my understanding perspective, and then do a bit of a question and answer session. So I've obviously had some experience dealing on the other side of the fence with doing environmental impact assessment approvals, both from what they call a coordinated projects under State Development and Public Works, and I've also done environmental impact assessments both as a consultant and as a regulator under the Mineral Resources Act and Environmental Protection Act. So essentially, as John was saying, there are three avenues to doing an environmental impact assessment. Two of them are state legislation, and one of them is obviously driven through the Commonwealth, which is the EPBC. Now, in Queensland, we have in place an MOU and a bilateral agreement which allows us to use the state process to conform and comply with EPBC permit approvals. So it does make it a lot easier getting your approvals now. So you don't necessarily, you still get separate approvals, but you don't necessarily need to go down two separate EISs or two separate processes. So in Queensland, for significant, well, what used to be called significant projects, they're now called coordinated projects under State Development and Public Works Act, which is through the Coordinator General's Office. So generally what happens is an applicant can apply for a significant, I keep using significant because that's the old terminology, but a coordinated project under the Act, and generally they will look at it and say yes or no, but it's based on whether or not there's complex state or Commonwealth approval requirements, so it does need the EPBC as well through the bilateral, or there's a lot of state approvals or local. There are some strategic significances in the locality or regional state. So obviously matters that might trigger World Heritage values generally will go through coordinated projects. The other one would be whether there's significant positive or negative impacts on infrastructure. So that's the economy, social or physical environments. Doesn't mean if it's declared by the state government that it is a coordinated project that they support the project. It just means it will go through the EIS process, which allows them to coordinate the response from all the regulators and all the approval parties to obtain your Coordinator General's report, which applies your conditions for the approval. You still have to get your approvals through SPA separately, but the approvals that you will get through SPA must reflect the Coordinator General's report and recommendations. I'm sure if that all makes sense. Now that's for coordinated projects. If you hop on the website, there's an excellent flow chart through the whole process. So you go through that process where you submit your project, you talk about whether or not what you're going to do. The coordinator will then declare the project coordinated. Then you'll do your draft terms of reference, and that goes out to all the departments and agencies. You get your final terms of references issued to the proponent. Then usually your consultant will draft up your EIS, and I've been in that role. It gets publicly released, goes through public notification, and then the Coordinator General evaluates your EIS, asks for additional info, may get public notified again, then they will accept, and finally you get your Coordinator General's report with your condition. And that will then be linked to your agreement. So the other thing to know under the Coordinator General's process for impact assessment, they now have a separate process. So there's environmental impact assessment, and they've got a separate process called an ARI, which is a impact assessment report. So it's sort of like a small EIS, doesn't need to go through the full terms of reference stage. So it's almost like they're shortcutting the terms of reference. May or may not need public notification, and it comes back to what the Coordinator General determines. And essentially, look, that's a short, sharp, very simplified cut down of what happens under the Coordinator General. Within the Environmental Protection Act, the process is almost the same. So rather than, the difference is you don't need to then go get your supplementary approvals for your mine and your coal, because that's coordinated and tied into the Environmental Protection Act and the Mineral Resources tenure that you need to obtain. It's all tied into one. So basically, in that very similar process, you develop the terms of reference, the consultant or the proponent addresses the terms of reference within the EIS. EIS goes out to public notification, goes to the Coordinator General, not the Coordinator General, goes to the department for assessment. They ask for more information, and then the department does a final assessment report, and basically they also issue the draft conditions which are applied to the proponent. So let's say it's a coal mine, and those draft conditions also get publicly notified as well. And so people can formally appeal, and that'll be done through LART, which is the land and I can't remember what LART stands for. It's the Land and Rural Tribunal. Anyway, so it's the Land Tribunal essentially, rather than the P&E Court. And that's essentially what happens with coal mining. Now, as I was saying, I'm currently a witness in land court for a major coal mine, which I can't talk about too much. So, but I know that's holding up a few other applications I hear. So that was for an extension for a coal mine. I was working at the mine itself. I've been involved in doing impact assessments on some rather large coal mines in the Bowen Basin back probably 5-10 years ago, and as well as that, done a few, been involved in EISs both from a regulatory point of view and an assessment point of view and compliance point of view, both in the marine sector and the coal mining sector. Some of the examples I can give would be, I can give an example where I've worked with EPBC, working as a consultant. I was working on a particular marine project, and this particular project was a small side project at a marina, had both state approval, town planning approval, had a detailed environmental management plan. What had happened is that we'd gone through the self-assessment process under EPBC and determined that, look, it didn't need referral. We then got a complaint to the Commonwealth. The Commonwealth said, maybe you should refer it. But we said, no, we don't want to refer it because we've already got state approvals. And that's a case where we could demonstrate that we've done the self-assessment that the legislation requires for EPBC, and we didn't feel it needed it. The regulator in that case, their whole argument, really, they just wanted us to refer it so they could tick the boxes for the complainant, you know. Sometimes common sense needs to prevail in that case. There was no impacts. It was overall beneficial, and the process had appropriate mitigation measures in place.
And Phil, if I could just interrupt there, ultimately it is up to the proponent of the action to consider if the proposed action needs to be referred. So that's, I guess correct. What you said there is that this is an example of where the proponent has actually made that consideration and said no.
Yeah, and look, you should always do your self-assessment just to cover your risk from a risk point of perspective. And if there are going to be impacts of matters of national environmental significance, then you should always refer it. And then the Commonwealth will determine whether it's a controlled action or not. In this case, there was no impact on any matters of NES, that's a short version. And we didn't refer it. And that was the argument we actually had with the Commonwealth. And yeah. And
the test is whether the proposed action is likely to have a significant impact. So there's correct. Two key words there, isn't there? Likely and significant. Yep. Fail in either of those and the referral does not need to be made.
I mean, look, coming from central Queensland, this was a coastal situation. The only matters of NES in the area were crocodiles. And really there was no impact at all on crocodile habitat, crocodile vegetation. The work was being done in a reclaimed pain paddock. So, you know, there was no environmental risk whatsoever. And we can demonstrate that quite clearly.
Thank you. And we may have some questions. I'm not sure if anyone does wish to ask a question. Please just unmute your microphone, or if you prefer, use the chat facility. And of course, Phil, the process of obtaining environmental impact assessment or going through that assessment process is quite different to the referral process. I mean, they may involve common factors, but they're quite separate techniques.
Yes, they are. Yes.
So yeah. If I could just talk about, I mentioned at the start when we might need an environmental impact assessment. It seems to me that what we need to do is the developer typically would perhaps prepare an environmental impact statement, and that statement is then presented to the officials for a review. Is that the way it works in practice?
It is, and that's similar to the mining one. It has a slightly different name, but essentially you put a statement of intent in for the mining, and for coordinated projects, yes. And essentially they look at the details and look at whether or not that's going to trigger an EIS. So in mining, some of the triggers are, for instance, the tonnage rate of ore that you will be extracting, which is generally about 2 million tonne. We do see a lot of approvals for 1.9 million, not 1.95 million tonne per year. But it also looks at what things you may be impacting. So obviously, if you're if even if it's 1.5 million tonne, but there's going to be impact on brigalow, which is an EPBC listed species and listed under the Nature Conservation Act, the department will go, sorry, we still believe you need to do an EIS. So, and that's done in the mining sector, and very similar to what can happen in the coordinated project sector.
Thank you. So in terms of making the referral, you've got to ask yourself, is the proposed action likely to have a significant impact on a matter of NEM, National Environmental Significance, or NES, or if the action is likely to have a significant impact on the environment in general for Commonwealth agencies. So there's a number of tests that developers need to consider, and of course their consultants during this process.
And there is guidelines about how you do your self-assessment first to see whether or not you should be referring it. And we're talking Commonwealth legislation here, and it sort of also assists you in understanding what is significance. So you need to look at the guidelines, and that'll help you spell out what they believe, you believe, or what the potential impacts could be, and what may be the mitigation measures. So.
And just in terms of case studies, there was an application made for carbon calcification plant in Gladstone, going on 15 years now since that occurred, and I understand that application was referred and considered. I'm sorry, it was considered under the legislation. Able to comment on that or any other case examples?
Yeah, sure. You can get examples where it will be referred and can be consorted. It's not a controlled action. So I think in the case you're talking about, I believe it's like the project never actually went ahead, but in that case the Commonwealth decided that it was not a controlled action. Exactly, but you can have a case where you can actually have a controlled action but not require an EIS. So they will say, yes, we believe this is a controlled action, but you just need to develop an environmental management plan, and they will accept it. So it's sort of like a limit. It's controlled, but it's limited. So a full EIS isn't required because it's not, the issue isn't big enough to warrant an EIS.
Thank you. So it's a whole range of different questions that developers need to ask themselves. Now, I'm not sure if we've got any questions yet. Yeah, Liz, have you got a question you'd like to ask? Thank you. Thank you.
Yes, please. I've got two questions. I'll start with the first one. When doing reading, well, here in Victoria, and I believe it's the same in all states, the words best practice seem to appear in a lot of documentation, and I was just wondering, when it comes to best practice, it could be relevant in one state or one area depending on the different soil types, the areas that you're in. How does a scientist determine what is the best practice and how often are they reviewed? That's the first question, sorry.
And that's a really good question. There's a lot of arguments about what's considered best practice. I think as regulators, generally people fall back on I can't say it now, the principle of caution. As a regulator, yeah, thank you. But the regulator will look at that and look at what best practice is. Now, obviously, best practice varies depending on, like you said, where you are, the geology, but also best practice does actually consider economic and practical considerations. What works in Europe, for instance, may not work economically in another country. And there are arguments about that. And I'll for instance, in America, final voids in mine sites are usually backfilled because of the type of mining they do. In Australia, final voids are always left behind because of the way that they mine progressively, and they've always argued, whether you agree with it or not, that economically it's not viable because once you do your box cut, you then have to move the material sometimes 50 kilometres to backfill your final void. And that's always been the argument from the mining sector, because that, and again, that's what they consider best practice. And rehabilitation. There's many companies or consultants out there will have different views on what's considered best practice. So on a mine site, you will have different things being trialled to see what works for that site. And usually often it's innovative things that triggers what's best practice. And often at the end of the day, it comes back to what the community will accept, what the landholder at the end of the day will accept, and what the regulator will accept. So, and those three things usually at the end of the day, determine best practice. Because what works in one country won't work here. What works in Victoria, I mean, we struggle with regulators from Canberra going to places like Cairns who have no understanding of a cyclone or the tropical rainfall or intensity. Victoria is very different, or you get people, I'm now in central Queensland, we get very sharp, intense rainfall. So when you look at the rainfall data, it doesn't indicate that. So best practice will be very different here for sediment erosion control. Yeah. I hope I've been able to, yeah.
Yes, thank you. That made it a lot clearer because it was getting very confusing when you're confronted with different government departments, and you can have 3 different departments having a different determination of what is the best practice, and then the landholder in certain situations gets caught in between the different arguments, and that leads to the next question in regard.
Can I give an example of that? Exactly. There's a particular project in central Queensland, I won't mention, it's finished now, and we had 3 different, and I think we talked about this last time in the last presentation, we had 3 different consultants working on a very similar project following the same corridor for pipeline, and the measures that each company put in, even though they were right next door to each other for their sediment erosion control and how they dealt with creek crossing, were all very different and all accepted by the government and the community. It was actually quite a good example of every consultant had different versions of best practice. So, and it is a bit of a moving field all the time, because they will always argue from the technical and the scientific point what's best practice, and they always argue that and some people will often argue on the cost-effective side of it as well.
Great, thank you. The other question was, like you've discussed about, I heard coal mines and, different developments, but what happens when it's actually a government project and they've, say the community say, no, that needs an environmental impact statement done because of this heritage significance, etc., etc. Usually the state department is not very forthcoming in telling you that it can be referred to a federal, like I've just found out, for the a federal matter when it becomes a heritage area. If they determine, like it goes to the federal, and then they determine that, oh, everything's okie dandy, rip that up and plough that down and just level it. How can you still fight for that environmental impact where you've got, say, sand dunes where the wind can blow the disturbed soil into the river and change the course of the river? But if a government department says that, no, there's no environmental impact statement required, is there a way that you as a lawyer could still take that matter on?
The best way... Sorry, I'm getting a bit of feedback, but the best way to deal with that, and I'm thinking out loud here, because you've got a state, I mean, in Queensland there's not much being done by the state government in projects at the moment. Even state departments and state governments must comply with the regulations. So in Queensland, for instance, main roads will run a project. They still, if they're triggering EPBC or they're triggering the EP Act, the relevant officers still are obliged to implement the same process as they would for a private developer. But you're talking about a particular case where the development is going ahead, the department's possibly referred it to the Commonwealth. The Commonwealth said it's not controlled action. That does get difficult. And if you're talking cultural heritage, obviously, I know in Queensland we've got cultural heritage legislation which talks about the level of disturbance. If the ground's disturbed, you look at it, it's a sort of a risk approach. Yeah, I don't know if I can really answer that question for you, because once the state government departments have really made a call on it, it really is official. Unless there's some measure of appeal, and so unless you're a formal submitter through the process, and that only happens in the EIS process. You know, as you're aware, you've got that opportunity to be a submitter, or under SPA. Yeah, there's really little you can do. I'm afraid I really can't give you a good answer on that one.
Perhaps if I could just add a few comments there. We've been talking mostly about the Commonwealth legislation and the approval regime as it appears under the State Development and Public Works Organisation Act. So bear in mind that you've got the basic dichotomy of SPA matters, which relate to impact assessable developments, where submitters can become involved, etc., and we're dealing purely in that state regime, as opposed to what we're talking about more tonight, which is the Commonwealth regime, EPBCA, and those matters that might have national environmental significance. Now, there is state legislation, in addition to SPA, that is highly significant in this area as well, and that is the State Development and Public Works Organisation Act. We've talked about the State Coordinator General having some involvement in certain matters, but large projects, and I think this is what you're getting at, Liz, may deserve extensive comprehensive appraisal, and the environmental impact statements undertaken under the SDPWOA in Queensland relating to coordinated projects, they're overseen by the Coordinator General, and they need to be very comprehensive. So that's one aspect of it. But going further, under that same Act, the Coordinator General, if you like, represents the Crown and can exercise all the powers and privileges and rights and remedies of the Crown. That's Section 9 of the Act. So in other words, the Coordinator General becomes a corporation in its own right. The Coordinator has very special powers that are not afforded to others. And this is really at the heart of what you're saying there, Liz. So there are certain duties imposed upon the Coordinator General under the Act, but the Minister responsible may go further and declare a project to be a prescribed project. That's in Section or Part 5A of the Act. And to qualify as a prescribed project, the Minister must be of the view that it is one of significance, particularly economically and socially, but be particularly significant. This is for Queensland, of course. And there's another kicker to this, and that is, with the Minister's approval, the Coordinator General may elect to step in and assume responsibility for assessing and making a development or decision on a project. And that would be in place of the original decision maker. And then we've got an entirely different ballgame altogether. So if the Coordinator General does issue a step-in notice, the Coordinator General then becomes the decision maker. And once the Coordinator General makes the decision, the Coordinator General can impose conditions and nominate entities to ensure compliance with those conditions. Now, the thing is that if that happens, the decision following a step-in notice is final and there is no right of appeal. That's under Section 76P of the Act. So Cairns Shipping Development Project was coordinated by referral. They decided it should become a controlled action, and it became both coordinated at state and controlled in Commonwealth, and so different regimes apply. But Liz, that might be the example that you're talking about. And I don't have the New South or the Victorian counterpart, but that step-in notice is a very powerful thing. So I'm sorry, Phil, if that, hopefully that was in line with your question, Liz.
Yes, sorry. So a step-in notice is similar to a stop notice. Like you can have a stop action. where the action has to be stopped until it's further investigated?
Not necessarily. Basically, what happens is the minister has the power. So let's say under town planning, the council is the assessment manager, or another department is an assessment manager. So it might be the EPA or it might be council. If there's enough concern raised, the minister can ask the coordinator generals to step in and take over the assessment process, basically. So not stopping the work. What they're doing is saying, look, we have some serious concerns about this project. We don't think town planning in such and such council can deal with it, or the office of EPA can deal with it. We will deal with it at the very high level through the Coordinator General's office and go through either the EIS process or the the other process we talked about, the IAR process, which is the Impact Assessment Report, which is sort of a simplified EIS. So it's not necessarily stop work, but yeah, thanks, John. That was good.
Thanks, Phil.
A little bit different from Adani too. So I think someone asked that. So.
Yes. And Shane said that the company he works for has machines in India, and that works very differently over there. I'm sure it does too. Anthony, did you want to make any comment or ask a question about CSG in the context of what we're talking about? You feel comfortable on
sorry, that was just a comment about those Curtis Island projects that Phil was talking about, I think.
Yes.
And just for the sake of the people that are viewing this later, Tony, you were saying the risk of a government body takes when it doesn't do an EIS down the track. They may be forced to do an EIS, would put their project back many years, and you refer to Adani mine in that category.
Yeah, see, I used to work for Powerline, the high voltage power line for Queensland, and they used to automatically do, like for the high voltage power lines, they'd always do an EIS, because that way you could plan the projects out and you had a finish date. Whereas if you don't do these things, they might pop up later on and put the project back, and then you've got to fork out money. Was that Powerline? Yeah.
Yeah, because we used, when I was a consultant, we used to do the EISs for Powerlink, because they're a little like, they're like these the EISs you do for Powerlink are like these, very similar to these impact assessment reports. They're almost a little simpler. They've still got to be public notification, still got the process, but because it's considered community infrastructure, it's run through a ministerial process rather than, so it's sort of short vents dealing with all the different departments. It's quite an interesting one, because they consider it critical to community infrastructure. People having electricity is sort of somewhat important. So it does override the planning scheme, and it actually overrides some of the other legislation that might be pulled in occasionally. But you still have to do your environmental impact assessment and your community impact assessment and your visual one. It's quite interesting, that one. Yeah.
Thank you for that. Thank you, Phil. Sorry.
And I'm talking about Adani. I do know they did do a detailed EIS for their coal mine, transport corridor and port linkages. And of course, it's gone through and then it got through EPBC referral as well. But it's been caught up in legal appeals and you know, some of the assessments, but it's now been approved again by both state and Commonwealth. But I think it's back in appeal court again. So.
Thanks, Phil. I think Liz has another question. Thank you, Liz.
Yes, sorry. One question in regards to, you've got, like we're talking Commonwealth, and if you've got two different Commonwealth acts, say a Heritage River Act, whether this is in Queensland or Western Australia, anywhere, you've got a Heritage River Act and you've got a Cultural Heritage Act, the Commonwealth one, but both of them have different distances for where you're allowed to do the works. Like for Cultural Heritage it could be 50 metres from the actual outside perimeter of where there's the riverbank, because it's part of their cultural heritage, the actual riverbank. And then you've got the Heritage Water River Act that could say 100 metres away or 75, depending on which state you're in. How do you overcome things like that, where you've got two federal acts, legislations, but they've got different requirements for the distance you have to be away to commence work? Sorry, it's a bit, I'm sorry, I'm trying to be a solicitor without boundaries in Australia, so I keep on talking about Australia-wide, sorry.
No, look, in Queensland, we used to have the Wild Rivers Act, which would be similar to your River Heritage Act. Obviously, we don't have the Murray-Darling, so there's a whole bit of legislation that Queensland only has to deal with up in the Darling Downs. Often in legislation, there will be sections that will say if an act overrides another act. So I don't know these particular acts. So if you go into the detail of it and you go into the explanatory notes, often the legislation will say they sit concurrently or one act will override another act. So for instance, the EP Act in Queensland, the Environmental Protection Act in Queensland, sits concurrently with the Sustainable Planning Act. But then other acts, for instance, a good example would be the Commonwealth Communication Act, which is all about telecommunication infrastructure, pretty well overrides every single bit of state legislation there is, and as well as a lot of Commonwealth legislation. So it really comes back to the content of those acts. Now, if those two acts are concurrent, it will come back to particular triggers. So if there is a cultural heritage, you would have to go out and do an assessment to say, well, yes, there's a cultural heritage value here, so therefore the minimum distance of the 50 metres applies. Or no, there's no cultural heritage value, so thus it then reverts back to the other legislation.
And of course, you may need to refer to Hansard. And if I could give a plug for my YouTube clip on how to access Hansard, being very opportunistic. Thank you, Phil. Thank you for that question, Liz. Do you have any follow-up for that?
Oh, you're safe now, thank you.
No, Phil, I typed that I was very pleased with everyone's great work tonight in becoming involved and asking you some very good questions. And I'm very appreciative of your time. But I don't want to keep you too long, but I will ask one thing, particularly for those that may not have had the benefit of seeing your earlier presentation. Can you just perhaps give some indication as to the likely cost associated with preparing an EIS and going through the EIA process? Sorry to put you on the spot.
No. Look, it depends on the type of EIS, whether it's a significant project. So, for instance, a dredging project that I'm aware of that happened in North Queensland, that EIS was worth about $2 million. An EIS for Adani is going to be in the range of $8 million for a large coal mine, 8 million plus. So it really comes back to the extent of how many studies you need to do, what the terms of reference ends up being. Obviously, the bigger the impact, the more work you got to do, because you've got to do your hydrology, you've got to do your soils, you've got to do your vegetation, you've got to do cultural heritage, transport, community, visual. So it really varies back to the terms of reference. So your terms of reference may drop particular bits out, which brings the price down. So anywhere from 2 to 10 million is a good pump.
Thank you, Phil. Huge figures. And sorry, if I could just ask one more thing, and that is, if you could just clarify the whole bilateral agreement regime and how it works in practice.
Sure. I know we talked about this before. I haven't worked on practice for a while, but essentially the Commonwealth has basically accepted the process for the state government, so for the EIS process. So at the end of the day, and I'm not sure where we are with the bilateral agreement, there was a memorandum of understanding in place, which essentially says the Commonwealth accepts Queensland's process. At the end of the impact assessment process, the Commonwealth will issue an approval. When full bilateral agreement is in place, which I'm a little bit out of date, I haven't checked for 6 months, I apologise, but once that comes into play, they literally accept the state approval as the EPBC approval. So there'll be obviously a cover letter or something going along saying, yes, the conditions within the state approval are your EPBC approvals. So all approvals are conditioned appropriately, and often it's conditioned to achieve a particular outcome, you know, regulate mitigation measures and things like that. Don't know if that really helps.
No, that's great. Thank you very much, Phil. Phil, I'm conscious of your time. I'm not sure there are any other questions. If there are, now's your chance to come in. May I thank you very much for the way in which you've presented your material tonight. Your expertise is very much valued and appreciated. Thank you very much. So at this stage, I thank everyone for joining us live, asking your questions, and I'll stop the recording now. Thank you.